Hello, and thank you for joining us for the SLW Institute webinar 2021 update, Interplay between FDA law and patent law, avoiding indigestion after Belcher v. Hospira. A recording of the webinar and the slides will be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu, and they will be addressed at the end of the webinar or offline. We invite you to follow us on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to our panelists.
Thanks, Michelle. So this is Sunil Arora. I will be one of the four panelists here on this discussion of the interplay between FDA law and patent law. Just by way of background, and thank you all for joining us, and thank you to my panelists who have spent a lot of time putting together this presentation as well. So by way of background, my practice here at Schwegman has a substantial amount of medical device practice as a firm. This isn't a new topic as we'll be speaking about. Tim and I actually presented on this topic back in 2013. But so my practice, I come out of the medical device industry, and I handle a lot of medical device clients. So Tim, I'll turn it over to you.
Thank you, Sunil. I'm Tim Crispin, and again, I'd like to thank our fellow panelists and the firm for supporting this webinar. My background is somewhat similar to Sunil's, where I started out as a test engineer and later a design engineer for a medical device manufacturer, and then switched over to patent law. And I have a variety of interests, but also similar to Sunil, I would say that a lot of my work still is in the medical device space. And I think what prompted us to look at this originally was sort of curiosity about how this, this sort of FDA related law, which we're, not domain experts as patent practitioners, sort of interacts with IP law. So I'm thrilled to be able to revisit this with some new panelists. So with that, I'd like to pass it on to Leah.
Thanks, Tim. Hi, everyone. My name is Leah Westman. I'm an attorney practicing at Schwegman with Tim and Sunil. My background is in my laboratory days. I was in a material science laboratory, and I've continued to do some material science and chemical engineering type work in my patent practice area. I also do a lot of medical device work and mechanical electromechanical apparatuses with the team here. Looking forward to chatting with you today about the intersection of the FDA and patent work. And as the team member with a little bit of a foot in the chemical world, I'll also be talking a little bit about patent term extension to you later. So something to look forward to. With that, I'm going to hand this off to my colleague, John.
Thanks, Leah. I'm John Swart. I'm also an attorney at the firm, and my practice is mostly medical devices. I do some HVAC, a little bit of software, a lot of mechanical and electromechanical work. Before I joined the firm, I worked in construction industries and cabinet industries, and I've got a chemical background, a bit of a musical background as well. So excited to be talking about these cases, and I'll pass it back to Leah as we begin the substantive presentation.
Yeah, actually,
thanks, John.
I'll step in and give a bit of an overview here, and then turn it over to Leah. So just by way of background, again, this isn't a new topic in terms of the interplay between FDA law and patent law, but there has been this recent case that's come out, this Belcher v. Hospira case, which I think makes it very timely to dig back into this topic. And there's also been some legislative interest in this area as well, so we'll be discussing that as well. So I think it's timely to revisit this topic. It's interesting because this topic is between the interplay between two different functions, and that's typically where issues can arise. If you have certainly in the handoff between two different functionalities, there's an opportunity for a fumble, much like in football. So it's the same story here. I think what you'll see as we go through these cases, there's an opportunity to fumble between these two different functionalities of FDA regulatory submissions and patent submissions. There's also, the issue where it's not a handoff, it's the same player, and that same player is actually running in two different directions, as we'll see from some of the interesting facts in these cases, where that can cause issues as well. So I think that the issue of the handoff and the interplay between these two different functions, that's what we're going to focus on here. We are not going to do a deep dive into FDA law, except to the extent that is necessary to talk about the interplay with the patent practice. And we're also not going to spend a bunch of time talking about real background issues in patent law. So we're really going to focus on the interplay. So this is our schedule for today. We're going to walk through a little bit about the FDA approval process. Then we are going to switch over to talking about 510K clearance versus PMAs. Item number 3 is substantial equivalence under the 510K, what the implications are from that, both for validity and enforceability and infringement as well. And then on the unenforceability issue, we're going to talk about the duty of candor, both to the FDA and to the PTO. Then we'll switch topics to talk about two kind of opportunities for regulatory personnel and patent personnel to work together. And one of those is the exemption from infringement under 271E1. And Tim Crispin's going to touch on that. And then we'll give it back over to Leah to talk about patent term extension for regulatory approval delay. And so with that overview, I will turn it over to Leah to talk a little bit about the FDA approval process.
Thanks, Sunil. I guess Jen and I were just very excited to jump into the substantive stuff earlier. So like Sunil said, we're going to start today with a little overview discussion of the FDA approval process. Not too much into the nitty gritty, but just enough to orient our discussion today. So typically the FDA approval process will start with identification of your device's classification. So under the FDA, there are 3 classes of devices: class 1, class 2, and class 3. They go in order from class 1 to class 3 of the lowest risk to the highest risk. And so how do you figure out what's what here? Well, typically a class 3 device, that's the kind that's going to be supporting or sustaining human life, and therefore is going to come with a lot more risks overall. So some examples, just for a little bit of orientation here: a class 1 device can be something like an oxygen mask or an electric toothbrush. A class 2 device could be something that's maybe like a syringe or contact lenses, whereas a class 3 device is going to be something more in the area of pacemakers, defibrillators, or other things that are going to associate a much higher risk in regards to medical treatment with them. So the way the FDA breaks this up is devices that fall into class 1 or class 2, because they were lower risk, they are submitted for what we call clearance under the 510K process, which we'll talk about a little bit. Whereas by comparison, the class 3 devices have to be submitted for what we call approval under the process called pre-market approval, or PMA. And so, of course, there are certain exceptions and things, but overall, typically your medical device is going to fall into one of these 3 classes, and you're either going to submit for 510K clearance or for PMA approval. So if we can move to the next slide, we'll dig into PMA a little bit here. So as we noted before, PMA approval is for devices that are used for supporting or sustaining human life, or that are of substantial importance of preventing impairment of human health. Along with this means that in some cases, class 3 devices present a potential unreasonable risk of injury or illness. So for this reason, the review under PMA of class 3 devices is much more stringent than 510K processes, because the FDA is looking at safety and effectiveness of this device. Because this is more stringent, the PMA process requires a full report of all information related to the device. This is things that are known, things that are published, investigations that have made into the effectiveness of the device, the safety of the device. I mean, as you can imagine, the list goes on and on. So if we go to the next slide here, some examples of submissions that are put in the PMA process include marketing and manufacturing information, such as pamphlets, references to performance standards, device descriptions, indications, fact sheets, information in preclinical and clinical studies, the labeling that may go on the device, and it gets quite extensive. It means that overall, the PMA process can be very costly, gathering all this information, and it can be very time consuming. You could wait for years in this case. So by comparison, if we go to the next slide, the 510K process that is used to clear class 1 and class 2 devices is very abbreviated. So one caveat here, 510K is generally available for class 1 and class 2 devices. There are a small subset of class 3 devices from before the 70s that can also fall under 510K clearance. But the timeline for 510K is much shorter. So the submission of the 510K has to be 90 days prior to the product launch, the day you're going to launch the device on the market. This is compared to a twice as long process for PMA review by the FDA. If we'll continue to the next slide here. So what happens in the 510K process? Well, first, the applicant, meaning the person who is going to sell the device on the market, has to notify the FDA. That means they submit a 510K. We just use specific nomenclature there. And what they do in the submission is you have the new device, and then they also have what's called a substantially equivalent predicate device. So my colleague Sunil will talk a little bit more later about what substantial equivalence means here. But at a very high level, it means that they're going to submit this new device, and they might say, okay, it's similar to this device that predated it, the predicate device, for these reasons, and it's substantially equivalent, meaning that it should also be safe and effective. And then the FDA will review that submission and hopefully will clear the submission. You'll receive a letter from the FDA where the FDA confirms that in fact the new device and the predicate device are substantially equivalent, and then you can go to market. So if we'll go to the next slide, where, well, 510K and PMA are the most common submissions to the FDA. There are a handful of other types of submissions. We're going to touch on one here, but just know that there are some other ways to submit devices to the FDA as well. So this is called a Denovo FDA submission, and this is a pathway where medical devices which would normally be classified under class 3 can potentially go through a less extensive process in the PMA process by going through de novo submission instead. So in this case, as you can imagine, with a class 3 device, there's no legally marketed predicate device, but they can show through the de novo process that there still is a reasonable assurance of safety and effectiveness. So, I mean, what does this kind of submission look like? It is what we call a 513F2 de novo request. It's actually also called evaluation of automatic class 3 designation, which can be a little bit confusing, but we'll touch on that in a second here. This type of submission also includes administrative information, devices use, device description, proposed conditions of use, classification information, supporting data. So it's kind of somewhere between a 510K and a PMA in terms of what's in the submission. If we'll go to the next slide, there are two ways to submit under de novo and with the FDA. So the first one, which came to use in the 1990s, was after the FDA has looked at a 510K submission. So let's say you have a device, you think it's going to fall under class 1 or class 2, you submit a 510K, and the FDA looks at it and they go, this is not substantially equivalent to a predicate device. We think this is going to have to go through the PMA process. You can then submit an evaluation of automatic class 3 designation or de novo request after the submission of the 510K to try to get on the de novo track. So this option has been around for quite a while. The other option for de novo FDA submissions was updated in 2012. And this one doesn't require you to first submit a 510K submission. Instead, if the requester determines that there isn't a predicate device that makes sense, then they can just straight away submit a de novo request before submission of a 510K and see what the FDA says there. So with that, I think I'm going to turn things back over to my colleague Sunil to discuss more detail about substantial equivalence of predicate devices under 510Ks.
Thanks, Leah. So I'll say a few words about substantial equivalence under the 510K, and then after that, we'll start going into some of the cases. And the cases are really factually interesting. The reason I think we start out with substantial equivalence under the 510K is it seems like the most logical place to look for an interplay between the FDA regulatory process and the PTO process. When you're going the 510K route before the FDA, you're basically making an assertion that your device is substantially equivalent in terms of safety and efficacy to some kind of a predicate device or prior art device. And then on the other hand, you'll find yourself in front of the patent office, and you're basically trying to argue for your novelty and non-obviousness of your particular invention, your inventive device. And so you can see that there's an inherent sort of a tension between those two different goals. And that's what we're going to dig into. Although that's not the only place that there's an interplay between the two processes. It's a good place to start. So in terms of substantial equivalence under the 510K, it does sound like it's much easier than a PMA submission. The process is you identify an existing predicate device. It could be one of your own devices, or it could be a competitor's device. And you demonstrate that there's safety and efficacy. Either the FDA will find substantial equivalence to that predicate device in terms of safety and efficacy, and that will imply safety and efficacy of your new approved device. So next slide, please. So according to the FDA, a device is substantially equivalent if, in comparison to that predicate device, it either has the same intended use as the predicate device and the same technological characteristics as the predicate device, or if it has the same intended use as the predicate device and has different technological characteristics, and the information submitted to the FDA doesn't raise any new questions of safety and effectiveness and demonstrates that the new device is at least as safe and effective as the legally marketed device, then that is also a basis for establishing substantial equivalence in terms of safety and efficacy. Next slide. So as we're going to be getting into, there are two things that are going on in this 510K. One is this actual assertion that you're making, that your device is substantially equivalent to a predicate device. But the other thing that goes into the regulatory submission is all the sort of supporting statements that support that assertion of substantial equivalence. And those supporting statements include certain things called technological characteristics. And those technological characteristics, as they're discussed in the FDA approval process, can include design characteristics, material characteristics, chemical composition, or energy sources. So the sorts of things that might also pertain to patented features as well. Next slide. So in terms of the 510K, the substantial equivalence assertion before the FDA, if the device has the same technological characteristics as the predicate device, what you'll be submitting is a summary of the technological characteristics of the new device in a comparison to the predicate device. And if your device has different technological characteristics from the predicate device, you'll be submitting to the FDA a summary of how those technological characteristics compare to the legally marketed device. So again, it's more than just an assertion by itself of substantial equivalence, but there's all sorts of supporting statements that go into the regulatory submission as well. Next slide. So what is this other information other than the substantial equivalence assertion that has to go into the 510K application? Well, it would include an identification of a legally marketed equivalent device, which could be a prior art device. It could be a device that is your own device, a previously marketed device, or it could be that one of your competitors' device. The 510K submission will also include a statement of intended use. That statement of intended use will talk about the diseases or the conditions that the device will diagnose or treat or cure or mitigate, and a description of the patient population for which the device is intended. And if you are relying on an assertion that your device is different from a predicate device, or if there are differences between your device and a predicate device, there will be an explanation as to why those differences don't affect the safety and efficacy of the new device. And these summaries are going to provide the basis for the FDA's substantial equivalence determination. Next slide. So as we get into this, you can see that the 510K has a number of potential intersections, areas of intersections with patent law. And really there's two major patent-related issues that we're going to be discussing in relation to the 510K. The first one is going to deal with, the patentability or the validity or the enforceability of any resulting patent that you get on the device that is also being submitted for approval to the FDA under the 510K process. And another thing that we're going to be talking about here today is any kind of implications in patent infringement suits down the road. But in general, before we get into that, I just want to, back up a few steps and think about this, from a higher level. I mean, what is really going on here between the two different processes, the 510K regulatory process and the different things that are going on the patent side? Well, if you think about what you're doing in terms of your own device, if your device is if you're going to be submitting your device, regardless of whether it's under a PMA or a 510K, once it does get approved, it is available as a predicate device for other fast followers to come on and to use as a predicate device. So the extent that you're putting your own device through the FDA approval process, you're actually making it easier for people to come after you and to do their own regulatory submissions. So in terms of the way to think about this as patent attorneys, it's really helpful to think about how the FDA 510K approval submission is actually greasing the skids for followers. And what can you do in terms of building a patent portfolio that can put roadblocks in that counter the effect of greasing the skids for followers by doing a 510K or other submission before the FDA. Next slide. So, treating the first issue in terms of patentability in the 510K submission, one thing to think about is novelty. And are there implications for novelty by the actual 510K submission? And that raises the question of, well, when does the 510K submission actually publish and become available as a printed publication or a prior art publication? So the answer is that when you do a 510K submission, that is all confidential information before the Food and Drug Administration, and it isn't until you actually get clearance that the 510K submission and summary get published. And all that supporting information then becomes available via a Freedom of Information Act request. And while it's true that, like any other Freedom of Information request, there is the opportunity for some sort of redaction. Once you do get clearance from the FDA, it is possible for things that are in your FDA file to become made available to others. So one interesting case that actually is worth looking at that really treated this set of facts is this Phillips case, Phillips v. Zoll. And Phillips v. Zoll actually treated the question of, when is the 510K available as a printed prior art publication? And under the facts of this particular case, the 510K didn't actually publish until after the patent filing, so it was not available as a prior art publication. But I think the bigger problem with these 510K submissions and the fact that they list predicate devices is all of that stuff is corroborative evidence of what else was on sale in terms of predicate devices and your knowledge of what was on sale. So that's where these 510Ks can really come into play. So that was addressed in this Phillips v. Zoll case. Next slide, please. I think maybe, just before moving on, in general, the patent filings are usually well out in front of the 510K submissions, but our best advice obviously would be to get your patent applications on file, before there's any possibility that the 510K submission can become some sort of published prior art against your patented device. Okay, so on this slide, we are talking about obviousness. Well, there's a lot of things that go into that 510K submission. And it's interesting to think about, not only novelty, would the submission itself impact the novelty of your patent application, but the whole question of obviousness. And as we're well aware, unlike anticipation, obviousness involves finding the pieces of a puzzle in various prior art references. And when you're in front of a patent examiner talking about, why your invention is non-obvious over the prior art, a lot of times all that's really lacking is a motivation to combine different references and, any kind of a notion of how that sort of combination might be made. And so it's worth thinking about how that 510K submission might inadvertently provide a motivation for combining different references or different predicate devices or evidence of any kind of a reasonable expectation of success. Because, a lot of times, that is how these 510K submissions are being characterized in terms of, the similarity to the predicate device. And then here in this last bullet point, it mentions that if the 510K submission draws upon multiple predicate devices and all the claim elements are present in those predicates in combination, does that increase the risk of an obviousness finding at the PTO or provide some kind of independent evidence of that? And so we'll just be keeping this, these are just some things to keep in mind as we run through some of the facts of some of the cases, which are quite interesting on these topics. Next slide. And with that, I will turn it over to my colleague, John Swart, to take us through the facts of one of the first cases here on patentability and the impact of the 510K.
Thank you, Sunil. So we're going to move through more of a panel discussion of some of these cases that deal with specifically the intersection between the FDA submissions and patent law. And this first case, we're talking about patentability or invalidity. So, and specifically in this case, we're talking about Sunrise's 510K notification and their assertion of substantial equivalence. So as we'll see as we walk through the facts of the case, this is a case where we have sweeping factual admissions from Sunrise that sort of look like they are talking about their device is identical to what was available previous to the device in terms of the 510K submission. And then, anyways, we have here this notification. They're talking about how the devices are fundamentally repackaged version of the predicate devices. They're using this harsh language. There's no significant changes. The dose methodology is substantially equivalent, and they even used the term identical in their 510K notification and their assertion of substantial equivalence. Next slide, please. But as we'll see, the court disregarded this 510K notification in terms of facially showing invalidity or non-patentability. And the court's reasoning here was that the 510K notification was exclusively for the purpose of showing safety with the FDA. Another interesting fact about this case, the 510K notification here was aimed at subject matter that was actually different from the patent claims. So this is sort of a factual pattern where it helps to have the patent claims aimed away from the 510K notification. But we need to remember that it can help or hurt. These factual assertions here, while not hurting the patentability of Sunrise's claims, could just as easy perhaps have hurt had the claims been more geared towards the gas dose methodology, which was the subject matter of the 510K notification. Next slide, please. So that was validity and patentability. So how does the 510K impact patent infringement? So I'm going to turn this over to my colleague, Tim Crispin, who's going to chime in on a few issues of infringement as they deal with 510K submissions.
Thank you, John. So we were just talking about patentability, and we were talking about the 510K serving as prior art or causing a problem from that perspective. But it can also cause a problem in terms of providing evidence of infringement. And so you submit the 510K, you get your clearance, it's confidential, it may be publicly available or discoverable later via FOIA or other means. The bottom line is that it can remain at issue long after the clearance process is completed and long after, any sort of grant of a patent to you as the applicant. But it also might be relevant in terms of demonstrating, the possibility that you're infringing somebody else's patent, particularly if you're relying on a predicate device from another company. And so just to review briefly for the non-patent practitioners, there are several different species of infringement under Title 35. So direct, indirect, induced, or contributory. There's questions of the doctrine of equivalence. And then from a damages perspective, obviously willfulness comes into play here. Next slide, please. So
thanks, Tim. So, sorry. So So just like we saw in the patentability topic with infringement, we also have substantial equivalence not by itself really being much of an issue. Just a plain assertion of substantial equivalence with the predicate device generally in these cases has not been shown to show infringement or to be a factual proof of infringement. So we see this in Johns Hopkins v. Datascope. We also see the courts being incredibly wary of confusing the jury with the 510K substantial equivalence assertion as some sort of a statement or advice to the jury. So in Medtronic v. Brain Lab, for instance, the court objected to the counsel's statement that Brain Lab had admitted equivalence because that would be confusing to the jury. And interestingly, even in Cardiovention v. Medtronic, we have the court admitting that the 510K evidence itself would be misleading and unfairly prejudicial to Medtronic for the same reason. But while the courts are wary of introducing this evidence to the jury, we've actually seen in litigation this get introduced in other ways. So, for example, litigators perhaps could introduce these statements through, for example, an expert witness or an expert witness testimony. And we've actually heard from colleagues of ours that this is quite successful in litigation. So we still need to be concerned about these sorts of, I suppose, the language that we're putting in our assertions of substantial equivalence, regardless of whether facially they can be shown to be admissions of patent infringement. Tim, any more comments on that?
Yeah, I think just that last bolded bullet, so if you think that a judge is going to be reluctant to admit the 510K submission into the record because of fear that it's going to confuse the fact finders, there are other ways that can get smuggled in. And, as we'll state over and over again later, that your 510K submission is a certified statement, submitted under penalty of perjury. And so it's going to be no different than many other documents in terms of the factual admissions that it contains. So that's all I have.
Thanks, Dan. Could you go to the next slide, please? Thank you. So while the factual admission, while the statements asserting substantial equivalence might not themselves be admissions of patent infringement, the supporting statements included in a 510K submission or another FDA submission can very much so be used by litigators to establish infringement. So we have a case, U.S. Surgical v. Hospital Products, and here we have a listing of technological characteristics that include that both devices had the same types of cartridges, staples, anvils, staple line configurations. In this case, we actually have the litigator using these statements to show infringement, despite the very statement from the applicant of the FDA submission not being admissible as admission per se. But we also have Abbott Laboratories v. Baxter, a similar fact pattern, where essentially the technological characteristics included, along with the assertion of substantial equivalence, are used to establish infringement. So Neil, any more comments regarding these technological characteristics that and their use by litigators?
Yeah, so I will jump really to this next point. So the bottom line is that it's not the statement of substantial equivalence itself that's often at issue because of the reluctances that judges have of confusing the jury. It's all the other stuff in the FDA file, including these technological characteristics. And whether they whether they help or hurt you is really going to be fact dependent. Sometimes those technological characteristics that you are identifying to the FDA will help you and can help refute an infringement case. And this Florida v. Orthopedic case is an example of that, where it's actually differences between the product and the predicate device that actually won the day, but they can help or hurt you. And the way they're typically framed in the FDA submission is in a way to draw similarities. So you have to be a little bit careful about what's being said to the FDA in terms of all of the underlying factual statements that are made, because they could help you, they could hurt you, and that's very fact dependent. John?
Thanks, Neil. Next slide, please. So in patent law, we have this body of law called the Doctrine of Equivalence. And essentially, for the non-practitioners, the Doctrine of Equivalence is just another tool that litigators can use to show infringement, where maybe all the claims aren't identical. So there's a test, and it's called the function way result test. And we've actually seen court cases where statements in a 510K submission have been used to show one of the prongs of the Doctrine of Equivalence test. So Abbott v. Sandoz while it doesn't constitute an admission of infringement, the FDA statement can be relevant to the function prong. And further, in the Hercar v. Bard, we also see that we, even though the actual filing was irrelevant because it was controlled, by a different agency, it also showed sort of this function prong of the test. So, and then just for completeness sake, there's heightened willfulness, willful infringement, and that's something we see in litigation where we can lead to increased damages if there's knowledge of, for instance, prior art. And it's just worth noting that for this purpose and for other purposes in litigation, these statements, whatever we have in there, can be used by litigators. So willfulness is something we ought to think of. But even some of these cases where we saw it not being an issue, we still need to think about how these cases actually play out in litigation. As we had said, sometimes while case law is telling us that the admissions cannot be used to be shown to a jury or something, we also can have clever litigators turn some of these statements into things that very much are admissible and can be used to show infringement.
John,
next slide, please.
John, do you mind if I just jump in before we go to the next slide?
Yes, please.
Yeah. So
thank you.
This whole thing on the doctrine of equivalence, it's interesting to me to see how natural the mapping can be between the FDA regulatory submission and the patent submission. When you talk about a test for infringement under the doctrine of equivalence, and it's framed in terms of insubstantial differences, and the very language of the FDA submission is substantial equivalence. So, I mean, it's just kind of an unfortunate set of mapping of words that are pointing in the exact opposite direction. And I think a lot of the underlying statements in support of the 510K submission, a lot of what's being done there is really talking about functionality and how things, how a new device doesn't function differently from the predicate device. So I think that there's just kind of this inconvenience in terms of how these different doctrines under patent law kind of unfortunately map over to things that are happening on the 510K side. And then, regarding the second point on the slide about willfulness, there's a lot of information in the 510K file about the predicate device. And it's, as we'll see going through some of these cases going forward, some of that can be, pretty damaging in terms of, if it doesn't get cited to the patent office, and especially if you have, the same person that's being involved with both sets of processes. So, when you talk about willfulness, if you go through, the whole history of willfulness and willfulness cases, there's a lot of cases that really talk about specific fact patterns where R&D people, knew things, and it was, beyond an actual notice letter, but it was, other aspects of being put on notice of somebody else's patent, and all of that stuff is, is material that can be found in the 510K filing as well, and that information can be used and combined. It may not be used in, by itself to establish a knowledge for the purposes of willfulness, but it can certainly be combined in this sort of a totality of the circumstances sort of test to establish knowledge. So thanks, John. That was all that I had to add.
Yeah, thank you, Sunil. So if we could go to the next slide, please. Here we just have a couple more cases for completeness sake, supporting just this main point that while the FDA submissions facially cannot be used just as admissions of infringement or even just to show invalidity, here these two cases deal with infringement. The FDA submissions can be used for other things in litigation. Next slide, please. So thus far, we've mainly talked about some of these consequences from the patent law side. And based on some of these consequences, or maybe in fear of some of these consequences, maybe we would be tempted to skimp out on our FDA filings. But we have a duty of candor before the FDA, particularly not to engage in puffery or to mislead the FDA. And there's actually some pretty severe consequences, as many people on this call and regulatory are likely aware of. So we need to be honest, and we need to submit a certification. And if we don't do that, if you could go to the next slide, some of the consequences sort of begin at enforcement actions for the company. We have personal liability of officers. We have potential criminal liability for fraud. So it's not as easy to say that our regulatory filings by any means, or by any and all means, should bend to some of these issues that we see in patent law with inconsistent filings. We need to be making sure that we're not misleading the FDA on the FTI side. Next slide, please. And so similar to that, we have a duty of candor before the USPTO. So even if we don't have an issue of invalidity, as we had talked about, or an issue of infringements, we could have issues of non-disclosure of information material to patentability. And that can result in the finding of unenforceability of a patent for inequitable conduct. And someone on our panel who has, a very lengthy history of dealing with med devices in this context, Tim Crispin, I'd like to invite him in to talk a little bit about some of these submissions, what should be submitted to the PTO, what we're obligated to submit, and how we can navigate this kind of difficult area.
Thank you, John. So as a patent prosecutor, the candor obligation is something that we take very seriously. And in some respects, it's kind of the bane of our existence, because in the garden variety case, we're submitting patent prior art. The examiner probably isn't going to rely upon it in, lodging a rejection. They're going to do their own search. And, we just want to have the presumption of validity, and we don't want to be vulnerable to a later assertion that we've essentially acted inequitably towards the office by failing to cite something material. And so I think that practitioners frequently think about this in the prior art context. The problem is that our obligation doesn't say anything about it being prior art only. And there's a lot of information that I think you could characterize as material that isn't necessarily prior art. And so this could include these regulatory submissions where you're making inconsistent statements, where you might not even be aware you're making an inconsistent statement, but your organization did. Maybe you have, and we're going to get into case law that's interesting about this, but maybe you have data that was later obtained where when you drafted the patent application, you made assertions about efficacy supporting the breadth of your claims, to either different classes of compounds or different device features. And as trials continued on, you found out that the results were inconsistent with what you had originally asserted. Adverse event reports fall into this. And so I think that the big takeaway from this slide is that both as applicants and prosecutors, we should consider that there's information that's not necessarily patent prior art that could be material, and where it's feasible to do so, we should try to identify that and cite it to inoculate ourselves against an inequitable conduct assertion. But unfortunately, not all that is knowable. And so, flipping over to being the adversary, and if you're trying to take out the patent in litigation, these other sources of information could be highly fruitful in revealing those types of inconsistencies, which is really, foreshadowing, the Belcher case that we're going to talk about later. So moving to the next slide, please. So since Therasense, there's really two prongs in the inequitable conduct determination, materiality and intent. And the materiality standard has been somewhat narrowed to but for materiality. So basically, a reference or other piece of information isn't deemed material unless it would have been outcome determinative, really. And that's a change. And that really, I think, was a reaction to a trend that had occurred where inequitable conduct was asserted in virtually every case. And so this heightened materiality standard, to some extent, I think has reduced the incidence of findings of inequitable conduct, but it certainly has not eliminated this as a risk. The other prong is intent. So please move to the next slide. And so intent has to be shown. My understanding of the prior doctrine is that heightened materiality could rise to a level where intent was presumed. And that's not the case now. We need to show intent separately. However, intent can be inferred. The problem is you usually don't have a smoking gun where somebody sends an email communication internally saying, I'm going to submit something to the FDA and I'm going to make a completely diametrically opposed statement to the patent examiner. And this is fraud, but it will get us a patent and it'll get us to approval faster. I mean, no rational person is ever going to provide that kind of documentation, even though they may engage in conduct that there's no other credible explanation for the factual record that you see. So intent can be inferred. And there has to be something more than just the fact that information was withheld. And so you really see this entire doctrine gravitating towards fraud on the office, and so it's essentially becoming, like if there's some species of fraud where you've done something that's really inconsistent, where there's no other explanation than you intended to do exactly what the record looks like you did. And, maybe there's, some mitigation for good faith. And as we'll discuss later, it's a bad factual pattern when the same person, is involved in both steps. If there's a principal investigator or a technical person or some other, high-ranking person in the organization that was involved in both the FDA submission and the patent filings, either supervising them or serving as an inventor, that's a much more difficult situation because now you can't really show that there was that there's some daylight between those two activities. You've got one person that knew both and might have acted inconsistently. So with that, let's talk about some specific cases. Next slide, please. And I think we're going to pivot back to Sunil.
Yeah. So thanks, Tim. I appreciate that. Just thinking about what you have just said, and it's becoming, I think, pretty clear that there's an opportunity to get yourself into trouble where the statements are inconsistent, and I think we'll see that coming up when we talk about all these cases. I think one case that doesn't really necessarily have to do with FDA submissions, but really stood out in my mind when it came out back in 2003 was this Rhone-Poulenc case. And this Rhone-Poulenc case was kind of eye-opening because this was basically a finding of inequitable conduct for failing to submit something that wasn't prior art. And in this case, what it was the patentee's own later filed, journal or later published journal article that made statements that were inconsistent with statements that were made in the patent application. So that is an example of inconsistency, and I think that it really makes clear that the duty of disclosure isn't just a duty to disclose prior art, it's a duty to disclose information material to patentability. And that duty is broader than just a duty to disclose prior art. To the extent that you're inconsistent in terms of your own later journal articles, or, I think one of the things on one of the earlier slides was, an adverse event report for clinical data or even post-release data, to the extent that that stuff is available, still during the time of pendency of the patent application. Those are inconsistencies. And if you think about it from a patent drafting standpoint, what are the things that you can do to reduce the opportunities for inconsistencies for things that you might not even know about until the product is actually out on the market and you start getting adverse event reports. And I think one place to look at that would be, to think about as a patent drafter when you start talking about advantages. that's obviously been a subject of debate as to whether to put all the advantages of the invention in or not to put them in. And I think they can be very helpful, certainly from a patentable subject matter perspective and from a non-obviousness perspective. But you may want to be a little bit circumspect that you're not stating things that are, so unequivocally put in terms of potential advantages of the invention, that if other data tends to come in later on that conflicts with it, causes real problems of inconsistency. So this Rhone-Poulenc case is, I think, one of my favorite cases in terms of, understanding that, the duty to disclose prior art, the duty to disclose to the Patent Office is broader than just prior art. It's any information that's material to patentability. And as practitioners, to the extent that we're made aware of it, we can certainly deal with that and get that information in front of the examiner. Next slide. And again, I think I already talked about the facts of this case, so we can just move on to the next slide. And with that, we're going to start getting into some of the other more FDA specific cases that deal with inequitable conduct. And I'll turn it back over to John.
Thanks, Anil. So here we actually have an inequitable conduct case dealing with the 510K submission not being disclosed. Well, we have art that was disclosed as part of the 510K submission. We have, this is a patent for a stair lift, and a prior stair lift was cited in the 510K submission as being similar in design and function to the unit that they were trying to get approval for. And then this case is interesting because we actually have the same individual involved in this FDA submission being shown to be involved in the prosecution of the patent. And to the PTO, Bruno did not disclose this Weckelator stair lift that they had helped them get FDA approval. And so we have this situation where essentially we're disclosing it where it's convenient, and we're not disclosing it where it's not for us. And the court came down on Bruno for this in the finding of inequitable conduct. And there were some things that Bruno argued that did not win the day here. They argued that their claim of substantial equivalence was relevant only for the purpose of securing FDA approval. That, while maybe it is an assertion that could be made in, as we had talked about in an invalidity case or in an infringement case, was not something that held any ground here in terms of inequitable conduct. And Bruno also tried to argue that despite its awareness of the prior art list, it didn't appreciate the Weckelator's materiality in terms of being a but-for reference. The court didn't find that persuasive. Next slide, please. And this is just a case similar to one that we'll see very soon here, the Belcher case of this month, where the facts are pretty bad for Bruno. The prosecution history had suggested that the only reason they had gotten the patent was by the lack of submission or the lack of disclosure of this reference. And Bruno's argument seemed disingenuous because the same person was involved in the prosecution of the patent as was involved in the submission of the FDA approval of the 510K. Next slide, please. And here, while this is pre-Theracense, sort of as Tim had talked about, these facts sort of show that this sort of intent could be still inferred because even without a smoking gun, even without a statement from Belson, the fact that this Belson character was involved both on the prosecution of the patent and the submission of the 510K seemed to be enough for the court to find evidence of intent. And further, they stated that here, because Bruno failed to offer a credible explanation for the non-disclosure, inequitable conduct was present here. Next slide, please. So what are some things that we can do to sort of avoid finding of inequitable conduct or activity that could be deemed as inequitable with the PTO? So as we'll see in some of the cases to follow, immateriality of information to the PTO or cumulative nature of the information can help mitigate a lack of disclosure of such material. We'll address that soon in a couple of cases. But something more interesting to talk about right now is the organizational structure. So as we saw in Bruno, the same individual was involved in the regulatory side as was involved in the patent prosecution. And depending on the size of the organization, that may be more common. If in a smaller organization to have the same person at least knowing about the happenings on both the regulatory side and the patent filing side, whereas maybe a larger organization potentially could argue, this is a question, not an answer, could a larger organization argue that sort of the right hand didn't know what the left hand was doing? Good faith is also something that can be shown to mitigate the finding of substantial equivalence. So this organizational structure, this whether the same person was involved, it's actually addressed in a case. Next slide, please. So in Ranback v. Abbott, the court just temporarily touched on this sort of idea of plausible deniability in a large organization for a lack of disclosure of something to the PTO that was disclosed to the FDA. So here the court talked about Abbott being a very large organization with many employees performing disparate tasks in separate facilities who cannot be required to know what each other is doing. The court preliminarily here found that Abbott failed to provide a credible explanation for the failure of disclosure of these test results to the PTO. And this is because they're highly material, and Abbott actually disclosed some other results. So the question perhaps is still open, and I want to turn this kind of back on the panel and see if anyone has anything else to offer. Is there plausible deniability for a large organization if maybe there's not an individual that could be tied, or is this something that maybe we should still be wary of relying on?
Yeah, so
Tim, Sunil?
I'll certainly jump in, and certainly it helps if you have a large organization, and I think courts will appreciate the fact that there's not that direct linkage. But if it helps, it's only going to help in terms of candor. Still doesn't help your validity case. And as we know, the best thing you can do to ensure the validity of your patent is to get the best art in front of the patent examiner. Patent examiners are pretty good at searching the patent literature. They're okay at searching the non-patent literature, not as good at that. And certainly they aren't as easily made aware of the products that are out there on sale. And so that is something that even within a large organization, and even if you can solve the candor problem by the organizational structure, and you don't have the same person doing both things, you still have this issue of there are things that are germane to the patent that may or may not be in front of the patent examiner. And then even on the candor side of things, you still have inventors, and even if the inventors aren't signing off on the 510K submission, there tends to be involvement with key technical personnel on both sides of the FDA submission and on the patent submission. And so even in a large organization, I think there is a risk of finding a trail between the two, and the fact that things just weren't being cited that should have been.
Thanks, Sunil. So we would like, if we could move to the next slide. Just one more point on sort of the same individual being involved in both processes of both agencies. We have a district court case that we found the facts very interesting for. This is merely a district court decision to allow the motion to amend pleadings. So it wasn't any actual real holding, but we have here Baxter, a very large corporation. They submitted 3 predicate devices to the FDA. And perhaps we'll retouch on sort of the amount of predicate devices to submit to the FDA, but this was an interesting fact to us because it certainly didn't help their case in the district court's decision. And many of the inventors were actively involved in the FDA submission. And here, unlike the AirSep case that we had talked about earlier, the claim breadth was anticipated potentially by the undisclosed pump products, the 3 predicate devices. And were even talked about as being material. So this followed Bruno v. Acorn, that we can still use these FDA submissions to establish knowledge or deceptive intent. So just more things to think about and watch out for as we start, formulating some takeaways. Next slide, please. So we've actually had sort of talked with regulatory people, and we've even had a question come up. Do we need to submit everything from the FDA file to the PTO? That might not be something that we want to do for various reasons, and it might not be something that we're obligated to do. And we have a couple of cases with sort of very narrow facts, but we wanted to bring up nonetheless, where information that was not submitted to the PTO, that was submitted to the FDA, was found not material. So here we have Pfizer v. Ranbaxy, and we have data submitted for Lipitor approval that was in an FDA submission, and we have a finding of no inequitable conduct for failure to submit the similar data to the PTO. And this finding was based on the credible assertion that the data was unreliable. And here we also have the helpful fact that the submitter of the data to the FDA was not the same as the inventor. So we don't have that nexus between the two agencies. But remember, and with all of this, with inequitable conduct, as Sunil had said, just because here we have a finding of no inequitable conduct doesn't necessarily mean that something that wasn't disclosed couldn't be used to show invalidity. Next slide, please. Here we have a drug company that failed to disclose some information to the PTO that was disclosed in their FDA submission. And in this case, it wasn't found to be material, thus no inequitable conduct, because the GI side effects that Abbott had failed to disclose were cumulative. They had been deemed to have been already submitted. Next slide, please. In those two cases, Pfizer and Abbott, we have a finding of no inequitable conduct despite a lack of submission to the PTO, information that had been submitted in an FDA submission. But we'd be inclined to say that it's not a safe assumption to say that it is all right to fail to cite data to the USPTO that had been cited in FDA submissions. These had really narrow facts. One case, the data was questionable and unreliable, as in Pfizer. The other case, the data was cumulative and had been deemed to have already been submitted. So we would suggest, just as a rule of thumb, to err on the side of caution and submit when possible, or be certain that there is some objectively credible explanation as for not submitting the information. Any other comments from the panel?
You know, maybe just addressing very quickly here to keep us on pace. You know, one question that just came in was saying, look, if you're submitting your 510K filing, it's going to go in the file wrapper, and assuming that the patent's file wrapper is publicly available at that point, which, you know, if it was at the 18-month mark or was in a continuation or something, it would be, you know, you're not keeping the 510K confidential anymore, and isn't that problematic? And I think I'd like to just ask my colleagues on the panel here if they have any opinion about that really quickly. But I would say that in that particular scenario, presumably what you'd be submitting is only the information from the 510K that is potentially material to patentability, since we're not making a recommendation that you just do a blanket submission. You know, as in this slide, we're talking about, okay, if you don't cite anything, that's not a safe assumption. But let's say that you want to cite stuff on a limited basis, you would presumably redact the other information that's confidential that you don't want disclosed. And that actually can cause its own set of problems in terms of sensitizing the examiner that there's more on the record there that they're not seeing. But I just wanted to address that question because I think it is a good question. It really captures very well the trade-off involved here where, yeah, you don't want to exhaustively submit your 510K without redaction, without considering whether there's other confidential information in there that you don't want made as, you know, as part of the public file wrapper of the patent application. And I just want to, you know, punt it back to my colleague.
Tim, so I'll just jump in too. And I know that we are running a little bit long here, so I'll try and keep us on pace as well so that we can make it through everything that we intended to today. But I will say that I think that submitting the actual 510K submission to the patent examiner, it risks confusing the patent examiner much in the same way that it risks, you know, confusing the jury. So I don't think that at present there's any specific obligation to do that, but as we'll be discussing, there may be some legislative interest in shifting the burden into actually doing just that. So we'll be discussing, you know, whether that might be something that's coming down the line. But, you know, in general, I would just say, you know, it is nice to get as much in front of the patent examiner as you can, and certainly to avoid inconsistencies, and that's the bottom line. And with
yeah,
that,
if you look at just a really quick point, if you look at the prior cases, what you're seeing is problematic is, you know, wholesale omission of material prior art, and so it doesn't matter whether you're submitting the 510K, you know, in the form of the 510K, it would probably be sufficient to discharge the Candor obligation to identify the art. And so, you know, that'd be my position. Anyway.
Thank you both. So next slide, please. We want to quick talk about the latest case, Belcher v. Hospira, that came in earlier this month. So there's nothing that's necessarily brand new law here, but definitely distinguishing of a lot of the things that we've talked about in terms of inequitable conduct. So here we have Belcher's patent for a formulation of epinephrine. And the formulation of epinephrine was based on sort of a critical pH range that limited or balanced racemization and oxidation, and thus sort of maximized the useful epinephrine that was produced. And so we have a new drug application to the FDA. And initially they had talked about a 2.4 to 2.6 pH range. We actually have on file, they revert to 2.8 to 3.3 pH range to their advantage in the FDA process, because there was a predicate device, there's prior art Syntactica batches. And they did this presumably to expedite their FDA approval. Now on the other side, with the PTO, they actually argued the criticality of the pH range. They made some pretty difficult statements to argue against later in litigation, and they said that the 2.8 to 3.3 range was unexpected for those skilled in the art, and that it allowed for the reduced racemization. Belcher didn't disclose to the PTO 3 references that were found to be material. And these 3 references were used in the FDA process. So the one was a prior art product that had been tested by Synthetica with the critical pH range. Synthetica's product was the second material reference. And then a third reference that actually had talked about this critical, as Belcher had stated to the PTO, range, being something that was very easy to achieve and something that was, it was done for other reasons in the art. So here we have a situation, this maybe has the worst facts of all the cases that we looked at today, where we're saying diametrically opposing things to each agency. We're saying that this 2.8 to 3.3 pH range for formulation of epinephrine is critical, it's unexpected to the PTO, but we're actually using that range to expedite our FDA approval and saying how it's no different than what had been produced before. And again, sort of like some of these other cases, you know, involving inequitable conduct, we have Belcher's chief science officer was, in effect, deeply involved in both submissions and examinations. So here, this is sort of a post-Therasense version of what we had talked about in Acorn. And we have the same holding. Intent actually is inferred still, post-Therasense, because we have all these characterizations in the prosecution of the patent of criticality over the post hoc rationalizations. And we also have intent inferred from the cumulative nature of the admissions. So, and
yeah, John, I would just
transition. And, oh yeah, go for it.
Yeah, sorry to interrupt. I was just going to agree with you that I think that it's worse than Bruno. And Bruno, it was actually just, you know, there was an omission of the predicate device. In this case, it's actually, I think it's much worse because it's basically, you know, the statements that are being made to the PTO that are just completely contradicted by statements that are being made to the FDA. So it's not just omissions; it's just complete contradictions in this case.
Right. So certainly interesting towards this body of case law that we've discussed, and we'd like to just move into a time of just kind of summing up our takeaways from the case law and also discussing some legislative interest in the issue. Sunil?
Yeah, okay, thanks. Next slide, please. So, you know, just to think about, you know, what are some of the things that you can do? I think I already alluded to one of those things as a drafter in terms of talking to advantages. You know, just don't go too far in terms of talking about advantages. Maybe talk about potential advantages when you're drafting patent applications, or, you know, things that can be factors that can contribute to advantages, because you don't know what you don't know in terms of, you know, what data might be coming down that might be contradictory. Then running through a few items, you know, in terms of on the FDA side, can you only disclose what's necessary to demonstrate equivalence from a safety and efficacy perspective? Again, as Tim pointed out, when you're putting these statements into the FDA, you're signing and certifying those statements. And so it's, you know, we want to be sure that you're very careful in terms of what you say, and you limit your discussion to things that are emphasizing safety and efficacy, and staying away from patentable features to the extent that you can, and to the extent that those patentable features don't deal with safety and efficacy. Two, in the FDA submission, is it possible to avoid overbroad statements of equivalence, saying things that are identical or things that might impact novelty or non-obviousness? So it may be a matter of just being careful in terms of how you put things in the FDA submission. Next slide. Item 3, well, you only need one predicate device. And so, and we've seen this in the facts, if you have more than one predicate device, you're just opening yourself up to more opportunities for issues on the patent side, both in terms of anticipation or in terms of obviousness. So it's probably best to stick to one predicate device, and if you choose that device with both patentability and infringement in mind, as well as substantial equivalence consideration. So what does that mean? If you have your own predicate device that you're able to rely on, that's probably better than choosing a competitor device, to the extent that that's possible. Item number 4 on this slide, as we have seen, it's not just the statement of substantial equivalence that in terms of safety and efficacy that's going to be a problem. It's going to be all that underlying factual statements that you make and that you certify in documents that are discoverable in litigation, just like any other engineering documents or company documents are. And then the last thing that we sometimes see in terms of regulatory submissions is we see people making some kind of a disclaimer defining substantial equivalence in accordance with the Food, Drug, and Cosmetic Act, and disclaiming, definitions in accordance with the patent statute. That may or may not help or hurt you, but I've certainly seen it done in regulatory submissions. Next slide. And then just by way of update we have this Belcher case that came out earlier this month, which is, really in line with earlier cases that we've seen throughout the years in terms of this interplay between FDA and patent law. But the other interesting thing that is from earlier this month is that there's now some legislative interest in the same topic. And this is a letter from Senators Leahy and Tillis to the PTO that are basically discussing this very topic of FDA submissions. If you go to the next slide, you can see that in this letter that is being sent to the PTO, what the senators are urging is that the PTO should establish a burden, to shift the burden over to the applicant to not make any sort of conflicting statements to the PTO, and that should be cause for rejecting the application, and when made knowingly and with bad intent, to potentially other sanctions as well. So again, there's some legislative interest in this, and that may increase the burden onto the applicant in terms of what needs to be submitted to the PTO. And so we'll just have to see how this all plays out. And with that, I will turn it over to Tim Crispin to walk through a little bit with 271E1. And I know we're running out of time here, so Tim.
Thank you, Sunil. And so I'm going to keep this brief. Our last two sections in the presentation are sort of mirror image portions of the patent statute. I'm going to cover what's called the safe harbor, or Hatch-Waxman safe harbor, which basically was enacted to balance, the rights of the intellectual property holders with also incentives, to get people to continue development and proceed towards FDA approval of new technologies that are potentially infringing, so they don't get penalized for working towards that approval process. So you can see the statute. Basically, it says that if the use is reasonably related to the development and submission of information under federal law, then there's no infringement. And so there's two very obvious questions. What is solely for uses reasonably related? And since the statute refers to drugs or veterinary biological products and goes on from there, it wasn't clear initially whether this applied to devices. Next slide, please. The short answer is that it does apply to devices, and it applies to all device classes. And so this Eli Lilly case and then the Abtox case answered those questions dispositively. And so it does apply to devices, meaning that if you are undergoing work and it's reasonably related to an FDA submission, you're going to be covered by the safe harbor, even if it's a device rather than a drug. Next slide, please. So now the question is, what does reasonably related means? And it turns out that the safe harbor, does provide a very broad, if not expansive, scope of protection to things that may, under an intuitive read, seem like they don't really fall under, wouldn't fall under, sort of an assertion that they're going to be related to regulatory submission. But as long as there's some decent prospect in this case that you're obtaining information relevant to a submission, you're in scope. And so in parallel with that, there could be other activities that relate to demonstrations, for example, or trying to identify clinical partners. And it turns out that as long as those things are not occurring in isolation and they're related, to this basically permitted use of gathering data in relation to submission, then they're permissible under the safe harbor. Next slide, please. And so another Ventratex case, explicitly stated, if you look at the last bullet here, which started out in a Northern District California case and then was affirmed by the Federal Circuit, even going around to shop for investigators is considered permissible, because you have to be able to collect the data for the submission, and you're undoubtedly going to need to do some fundraising, and you're going to need to identify clinical partners to conduct that. So it is a broad, it is a broad scope of exemption, but it's not without limit. Please go to the next slide. So it turns out that this Merck case said that even preclinical studies would be within scope, but there's not sort of an infinite scope to this, where if, temporarily you're just engaging in basic research, for example, that maybe someday would be used in support of, an FDA regulatory submission, that's out of scope. And there's some other activities that are out of scope as well. Next slide, please. Those would include things like stockpiling, and potentially we'll cover very briefly at the end, research tools exception. The only recent case I want to mention here, a couple of recent cases, are this Edwards case, which is basically the same, basically affirming the same practice that we just discussed, which is that Merck controls, in this case, Merrill transported their transcatheter heart valve and delivery system to UW, and then they also had materials that they took to a conference in France, and these were both deemed to fall under the safe harbor. Doesn't matter what their motive was. The assertion was made that they were taking it to this conference to promote rather than, for anything that's in support of an FDA PMA application. The court doesn't want to get into a debate about what the motives or purposes were. The use in that case was identifying clinical partners, and the demo units actually stayed in the bag even. And so this was deemed to fall under the safe harbor. Next slide, please. One other case to mention is this Amgen versus Hospira case, very quickly. And the safe harbor also applies to methods of medical manufacture. If I understand the facts correctly, in this case, there were batches that were being prepared, in support of FDA submission, but not all the batches that were being prepared some were being stockpiled for sale, and those did not fall under the safe harbor. But the court did affirm a district court jury instruction that it's not legal error to say, look, if the patented method, like a production technique, was used for a particular batch and that was reasonably related to submitting information, then it falls under the safe harbor. And again, there's an outer limit to this. Next slide, please. As a research tools exception, it's a natural question that if the patent actually covers like a diagnostic device or an assay or a piece of test equipment, the statute's drafted so broadly, the question is, okay, well, if you're using that tool and you're using it for something that's, an entirely unrelated FDA submission, but it is being used in support of an FDA submission, does that fall under the safe harbor? And no, because that device itself is not subject to the FDA approval process. And so I think we're right about at time now. I'm going to go back to Leah quickly to just mention the term extension.
Yeah, thanks, Tim. I'll try to go quickly
here.
Let's go to the next slide, please. So real quick, patent term extension. Many of you are familiar with this phrase. This can be granted for certain regulatory reviews where the term of the patent can be extended if there's regulatory delay. Specifically, in the context today, what we're talking about, it's for pre-market approval delay. And it means that a patent which claims the product that was under regulatory review could potentially be extended. It's most generally used for pharmaceuticals, but there are a number of medical device extensions that have occurred as well. If we could go to the next slide real quick, you can look up patent term extension on the US Patent database here. And let's actually flip to the next one because we're going to go to a few more practical tips here. So patent term extension has a number of requirements, one of which is the timing. So when you get approval from the FDA for your device, when that letter is dated and sent out, you have 60 days from that, within that window, to file for patent term extension under 156. Now, there are a number of other things that are required for patent term extension. So the patent that you're looking at, it has to actually claim the product that was under regulatory review, or claim a method of using the product or a method of manufacturing the product. The patent itself cannot have expired already, and the patent can't have been subjected to PTE already. Now, the product that is the subject of the patent for PTE has to be subject to this regulatory review prior to commercial marketing or use. And this means that PTE can be quite limited, actually, and you do have quite a number of qualifications you need to meet in order to get any PTE on medical device patents. If we go quickly to the next slide, the application here, it includes a lot of bibliographic information you can read off there, and has to be submitted to the USPTO director for review. Now, calculating PTE is actually a little bit complicated. So if we go to the next slide here, there are 3 important dates when you're calculating patent extension. The first is when clinical investigations began on humans with this device. And the second date is when you submit an application to the FDA, such as under the PMA route. The third date that's important is when the FDA approves the device. So the way PTE is then calculated based on these 3 dates is half times the number of days between the first date and the second date. And then you add that to the difference between the second date and the third date. So it can be quite a bit of term depending on how long you've been delayed. If we go to the next slide, however, there are a lot of caveats with PTE. So this is limited to delay under the PMA process, not the 510K process. There are a couple rules as far as the length of the extension. So the patent expiration date can't be more than 14 years from the date of regulatory approval. And additionally, the PTE, the extension itself, can't exceed 5 years. The big caveat here is if you have a portfolio of patents that relate to one product on the market, you can only extend the term of one patent correlating to each product there. So if we continue, the other thing to keep in mind when you're looking at patent term extension is that you can be subject to diligence challenges from third parties. So a party is diligent before the FDA when they are, being diligent during the period of regulatory review to get the device through regulatory review and onto the market. And if a third party thinks or challenges that maybe you weren't diligent during that regulatory period, then you might not be able to get patent term extension, or it might be rescinded in some respect. Couple more, and then we'll let you go. Next slide. There are a couple more caveats here, and patent term extension actually is different than patent term adjustment. Many of you are very familiar with patent term adjustment, PTA. That's the kind of term changes that occur based on the patent office delay. The PTE is based on the FDA delay. Because it's 2 separate agencies, the statute actually allows for this to be cumulative. So if you get some patent term adjustment due to patent office delay, that can be added to patent term extension from the FDA delay. Additionally, in some cases, terminally disclaimed patents can be eligible for a PTE exception. So if we'll go to the last slide here, we've got a couple takeaways here on patent term extension and the whirlwind that we just went through. So patent term extension can be taken into account during your FDA applications, whether you decide to go 510K or PMA. And there are a number of other things here. You can map patents to certain products that are going PMA to determine which patents you may want to apply for the extension under. So you can choose, quote unquote, the best patent based on things like patent strength, actual infringement, or amount of PTE that may be available. And additionally, FDA can communicate with your docket personnel to understand when these deadlines are so you don't miss the opportunity to apply for PTE. So a last key takeaway here is when you are doing your regulatory review with the FDA, keep an eye on that diligence factor, because you don't want to get to the end, apply for PTE, and have someone challenge your diligence. So overall, like high level here with PTE is coordination between your intellectual property and patent personnel, and the regulatory personnel can be very helpful in getting some patent term back through PTE. So with all of that, I think that was our last substantive slide. So we're going to wrap up. Thank you again for everyone for joining us, and those of you stayed a few minutes over. If we will take a look, if we didn't get to your questions, and see if we can circle back with you. But as we're over time, I think we're just going to say thanks, and hope that you'll tune in again for the next SLW Institute webinar.